Hello, my name is David Swighaft. I'm a partner at RSZ Forensic Associates, and I'm going to be talking about the discussion of fraud in litigation and investigation engagements. More and more frequently, I find that I'm asked to describe certain acts as fraud or fraudulent in connection with litigation and investigation engagements. The problem is that for a variety of reasons, we can't say this. We can't say it for professional reasons. We can't say it for legal reasons. Regardless of what the client, the attorney, or any other parties involved want, and they do want to hear this, we can't say it for both the good of the profession and the good of our respective practices. And I'm going to be talking about all of this and ways to get the relevant points across without violating those professional standards. First things first, let's discuss the elements of fraud. Fraud is a legal concept, and you'll find this in law books, you'll find this in statutes. You're not going to find a definition of fraud and case citations in accounting literature. That said, let's just talk about the elements of fraud for a moment. It's the misrepresentation or omission of a material fact made with the knowledge of falsity, made with the intent to deceive. Reliance is placed on this false information, and based on such reliance, damage is incurred. These are the legal elements of fraud. We can't say that this collection of elements, as we find it in an investigation, represents fraud or fraudulent act, because professional literature is pretty clear in terms of what we can say and what we can do as professional services. Let's start with the AICPA Code of Conduct, which says we can only undertake those professional services that we can reasonably expect to complete with professional competence. Similarly, the Code of Ethics refers to a member who performs auditing, review, compilation, management, consulting, tax, or other professional services shall comply with the standards promulgated by bodies designated by the council. None of the so-called bodies designated by council speak to definitions of fraud or that we can discuss fraud as a matter of professional accountancy. And last but not least, I want to point out Statement of Standards for Consulting Services, where in consulting service, the practitioner develops the findings, conclusions, and recommendations presented. None of these relate to legal concepts. There are auditing standards that discuss the consideration of fraud in a financial statement audit, and that fraud is a broad legal concept, and auditors do not make legal determinations of whether fraud has occurred. That's probably the clearest black and white deterrent to making these statements that I can think of. There's other elements in the professional literature. Practice Aid in 2014 for forensic accounting and investigative report writing that talks about factual findings and conclusions. These are all available for you to peruse. The point I'm making here is that you are precluded from speaking about fraud or making legal conclusions as a matter of our professional literature. Going beyond that, let's talk about our professional responsibilities with respect to the expectations of stakeholders. Think about the ultimate client in a litigation or investigation engagement. They're interested in we as practitioners discovering the truth and explaining it in a manner that is clear and concise and is relevant to their concerns, whether it be to quantify their economic loss, to identify the bad actors within an organization or other relevant information. The next stakeholder whose expectations we need to manage is the attorney. The attorney is interested in serving his or her client and in prevailing in a litigated matter, or again, getting to the truth in a matter and seeing to it that restitution is made or that the client is made whole relative to a bad act. Another stakeholder is the trier of fact, who is also interested in the presentation of fact in a clear and understandable manner in order to get to the truth, in order to arrive at a right and just determination. And in certain cases, you're dealing with regulators from various governmental bodies who are in the same position as the trier of fact. As to why we should not allow ourselves to be pushed into affirmatively stating fraud by a client or an attorney. As I stated previously, fraud is a legal concept. It requires a legal opinion, and unless you're an attorney, you really have no standing to make an opinion about whether or not fraud has occurred. The biggest risk of making such a statement would be that any testimony you make with respect to fraud and any related or unrelated testimony may be excluded, which would work to the detriment of the client, to the detriment of the attorney, and to your own detriment. You can be subject to a Daubert challenge, and you are looking at potential malpractice issues. These malpractice issues are probably the most unsettling because you would have violated professional standards and are thereby subject to professional liability prosecution. If the attorney or the client or even the trier of fact is looking for a black and white answer, is this fraud? Was this fraudulent? You can present the elements of fraud in the context of the facts that you've read, that you've discovered, that you've investigated, and break down that discussion into the elements as described in the general definition of fraud. Depending on the jurisdiction that you're working in, whether it be state court or federal court, use a definition accepted in that jurisdiction. Speak to counsel about that, look up relevant case law or statute. To address requests for some affirmative statement about fraud, the best thing I've found is to describe the evidence presented by the bad actor or actors and how it's contradicted by other statements, evidence, or facts, thereby defining by itself the falsity or omission of those facts. Again, don't conclude about the evidence other than how it isn't supported by the facts. Then you would close the discussion with an explanation about how one party was damaged by their reliance on the facts, that the facts were misrepresented or omitted, and that the facts were material. How the bad actor knew about the facts, and the falsity in making his or her statements, and that there was motive to misrepresent or omit the facts, and then as a byproduct of the work performed, there is a quantification of the damages suffered. This is all a long way of saying that as a practitioner, it's your opinion that is your stock in trade. That is what you are presenting to the court, preparing and expressing on behalf of the attorney and their client. and the trier of fact is basing their decision on that. As professionals, we are required to remain independent and objective and to be an advocate for our opinion and only our opinion. By following these guidelines, you can limit the risk you take when you're performing forensic engagements and provide the best possible presentation of your findings on behalf of your client in order to help them achieve the best possible outcome.